Good Saturday afternoon here. Carl Rominger coming live here from the WHP 580 studios. It's a show where I answer your legal questions. Okay, Lewis. Lewis, you're on the air.
Yes. Yeah, I was wondering, I have a couple questions. I'm going just through a recent separation and wanted just to get your thoughts if I have any kind of adultery claim here, and about maybe if I have to pay anything out of my pocket right now for her for living expenses and things.
Gotcha.
Long story short, my wife and I met a gentleman. We were out to lunch one time. We were invited to his house. We never went, but she continued a relationship with him unbeknown to me. When I found out and confronted her about it, she told me that the gentleman was gay, that I didn't need to worry about it. A friend of mine saw them at a bar near his house. When they met, they hugged and kissed, and I showed her picture to a bartender there, and he told me that they frequent that bar there quite a bit, and he thought they were a couple. Now, she had told me sometimes that she was there with him and sometimes not. But again, when I asked her about this gentleman, she told me he was gay. Well, within a month, she left him and moved in with him in his home.
Okay.
And so now basically she's telling me that, she wants a divorce, but I'm going to have to pay alimony, or I got to pay her now to keep her living expenses going. And I just really don't understand everything. What are my options? What am I liable for right now?
Well, she could file right now. If you guys are both separated, when spouses are separated, whether a divorce has been filed or not, either side can file for spousal support. But spousal support flows from the person with the higher income to the person with the lower income. But adultery, cohabitation, and fault are bases not to get spousal support. The rub is if she files a divorce, then she can go for what's called APL, or alimony pendente lite, which means pending the litigation. And alimony pendente lite is calculated the exact same way, basically, as support, but fault is not an issue, just the pendency of a divorce action is. So if you have a higher income than her, you will either end up paying, if you have children, it's 30% of the net income difference after child support. If there's no children, it's 40% of the net income.
Even if she's living with the guy?
For APL, yes. That's irrelevant. If you follow me on spousal support, that would prevent it. Once a divorce is filed, okay?
So then the key is to get the divorce filed as quick as possible.
Well, once it's filed, then she can get the support. So you might want to do, if you came to see me, what I would tell you to do is let's work out a comprehensive marital settlement agreement, propose it to her, and get her to sign it before we file for divorce, and as part of it, have her waive alimony and alimony pendente lite. If she was smart, she'd just go ahead and file the divorce and whack you for APL. So hopefully she's not listening, right?
Well, no, but she just has friends that are lawyers in this circle that she's hanging with, so I'm sure she's probably getting some kind of advice like that, which, she also told me that she could make me keep her on my medical coverage for 2 years and things like that. So I just. Well,
what she means by that is she's not going to grant you a divorce for 2 years. In other words, both sides have to consent to a divorce, and you can't force it until more than 2 years have passed. That's because our legislature years ago, in order to get no-fault divorce passed, had to compromise with interests in the state who believe that an easy divorce is immoral and going to cause the breakdown of society. So now, if you guys agree, you have to wait 90 days. But if you don't agree, if one of you says, I'm just going to make the other guy wait, you can make the other person wait 2 years before you can be forced into granting a divorce.
Well, then that doesn't sound like she got good advice, because I think if she would go for the alimony that she'd want to pay, that you just mentioned, that
as soon as possible.
Yeah, you would think she would want money rather than tell me, well, I'll just let it go for 2 years just so I got your health insurance. But
well, and you know what? If that's what she's running with, maybe you don't kick the sleeping dog. Now, if you came to see me, here's what, just to give you an idea of the process. Let's say you just rolled into my office. Hey, Carl, I'm a potential divorce client. What I would have you fill out is a pretty lengthy questionnaire which goes through all your financial assets, income, liability, what we know about the other spouse's income, liabilities, et cetera, because obviously we don't always have perfect knowledge. Some marriages we do, some we don't.
Right.
And then we would crunch various numbers and try to calculate a strategy. So sometimes I go to people and I say, you don't want to file a divorce yet. Let them cohabitate and live out there. Keep them on the health insurance, particularly if it's not costing you that much extra. Because once we file a divorce, they're going to go see a lawyer and might find out they can get APL. Other times I tell people, well, your incomes are about equal, so let's just get the thing rolling. But a lot of times we can resolve these things if we can get an agreement up front. as to how everybody's going to handle things. And sometimes that agreement even includes not a fast divorce. It says, okay, I'll keep you on the health insurance. We'll sign the house over this way. We'll do this with the pensions, etc. But just to give you an idea of the process, we have to get all that information up front and then strategize what's best for any particular marriage. So my advice to you and anyone else out there is don't just do it the same way your friend did it or you heard somebody else did it, because every case is unique. And obviously what a guy like me sits around and tries to do is find a strategy that's going to maximize your emotional well-being as well as your financial well-being.
Well, does my adultery have any bearing or any matter then really in this case other than just to prove fault and maybe not get payment afterwards? And with what I have, is that an adultery case?
If she's cohabitating, it's probably adultery. Of course, we always joke, how do you prove it?
Yeah, I mean, that's what I'm saying. But she, was meeting the guy. I mean, I know she was calling him, texting him, things like that. It wouldn't be hard to prove.
Courts use the adultery factor as one of many factors generally in equitable distribution. So, and I shouldn't say that. I shouldn't even say it that way. Fault in the marriage or fault in the breakup of the marriage is something that the court considers, and adultery is one of those things that we consider faults. I shouldn't say they consider adultery; they consider fault. Nonetheless, it's one of many factors in the modern era when you can get divorced for any reason. Basically, it becomes a very unimportant issue unless it's egregious. And then the weird thing is, of course, you can always reconsummate a marriage. And so, if you have a serial philanderer in the marriage, and let's say your wife has stepped out, 27 times over the last 28 years, every time you take her back, we say you've forgiven her, so we don't care about that past bad behavior anymore.
Gotcha.
All right, brother.
Okay, man, I appreciate the advice, and maybe coming to see you.
All right.
Website, there's good stuff there. Thank you.
Thank you. I think he's referring to weekendappointment.com, so just go to weekendappointment.com if you want to contact us or see what's going on. 540-0580 is the talk line number here. Skip, you're on the air with Carl Rominger.
Hey, how you doing, Carl?
Good.
Hey, I have a question in regard to a durable power of attorney.
Okay.
In 1993, I had a durable power of attorney set up, and I had my sister appointed as my legal representative. It came to the point last week where I had to invoke that, and it was with a financial institution. Went to the financial institution. My sister took the durable power of attorney there and showed it to them and wanted to withdraw some money from my account, which I had given her permission to do. And I even talked to them on the phone prior to that. They said, well, they have to send it to their legal department. Well, that took 3 days before they got anything back from that. They came back with an answer stating that Pennsylvania law had changed, and now that the whole document has to be all in caps. So does that make anything prior to that all null and void because of a technicality or a change in laws saying that instead of small letters you have to have caps even if the wording is exactly the same?
The short answer is I don't think it voids any existing power of attorney. We've had this problem. With a couple different banks over the years where they take a view that they are not going to accept a power of attorney unless it is compliant with what they believe, and I notice I say what they believe to be the current status of the law. And so they send it off to some legal counsel somewhere who then dutifully bills them to give them an opinion on it and says, well, there's something wrong with this one because it's not up to date or it isn't in the exact form. It's not supposed to void it. Now, when the legislature has passed these amendments, they're all retrospective, not prospective. I should say they're all prospective, not retrospective, meaning they don't go backwards. And so, no, as a general rule, we take the position as attorneys that it is valid until revoked, hence the concept of durable, and the legislature doesn't make it non-durable by changing the requirements. It's just that at the time of creation, if it doesn't meet the requirements, then it's not going to fly.
Right, that's understandable. So what do I do in a situation like this where I have to have the thing all rewritten and just make it all in caps?
Yeah, and I'm not really. I guess they're probably referring maybe to the scary warning on the. What year did you do this thing?
1993.
Okay, you did it before the amendment, which puts the scary capitalized warning on the front. That's what they're probably talking about. Mm-hmm. There's a standard warning that goes on the front of all powers of attorney by statute now, and then an acknowledgement on the back. It's really not that big of a deal to redo. The short answer is, I assume, are you mobile? Can you get around?
No, I'm confined in the hospital right now because of my condition.
Well, the good news is most hospitals have a notary, okay?
Mm-hmm.
So if you were to have your sister or whoever's mobile get a hold of me off the air, or you get a hold of me off the air, we can redo your power of attorney and get it sent out to you, and you can get it notarized at the hospital.
Okay.
And we do that quite often. I sometimes visit hospitals, so there's more expense in that. But you don't need me after I've talked to you and you seem competent and of sound mind, right?
Mm-hmm.
So I would be fine sending you one to have done yourself. But I'd want to talk to you. You never trust the nephew, that calls you up and says, "Oh yeah, my grandpa needs a power of attorney. I just he can't make it in. So if you just fill it out, we don't do that. But if I've talked to you and I'm satisfied, what we can do is just type you up one, get it FedExed over to you, and or have a family member come pick it up, and then the hospital will provide you with a notary."
It just seemed ridiculous as heck. That's like saying that they changed the marriage law or the real estate law, so all prior deeds, because of the wording of the new deeds, the new marriage licenses, they're all null and void.
I think that the bank has taken the wrong position on this.
Yeah.
I don't think they're required to honor a power of attorney. I don't know if they're required to. What I would advise you to do is call the bank up and say, "I'm switching banks."
Oh, I already did that.
Good.
But this is just a good example, and people should keep this in mind, that it's a good idea occasionally to review your documents that you have like that to make sure that they're in compliance, so you don't run into a situation like this.
And Skip, that's what I've told people when they have older powers of attorney. I said, you don't have to redo them, but you should, and here's why. Right. And this is exactly the case, so I appreciate you highlighting it. I got to go to break, but if people want to get a power of attorney from us, you go to weekendappointment.com, fill out the free will kit. We not only do a will for free, but then for a very modest fee, we do living wills and durable powers of attorney as well. So,
hey, thanks a lot for your help, Carl.
All right, Skip.
I appreciate it.
Thanks.
See ya.
540-0580. See you after the break. Hey, welcome back. Carl Rominger here, answering your legal questions. 540-0580. And I'm going to do my best to answer them. We've had a pretty good round here. We just had a fella call in, talk about a bank not honoring a power of attorney, saying it isn't up to the legal snuff or the most current version that the legislature requires. As I pointed out, he was correct that it doesn't change. It was written before those requirements, and those requirements were not meant to invalidate documents that were created before it. But a lot of institutions, banks, and other nervous Nellies will not honor them. So if you haven't updated your power of attorney in a long time, or you haven't looked at your living will, or you haven't had your will reviewed, make sure you go to weekendappointment.com, fill out the form. You join as a member. You can then just download a form, you fill it out, you send it in to me, get a meeting with me, and we go over everything line by line. If you bring your old documents along, we'll look them over, and I'll tell you if you need to do anything to them or if they're compliant with the State of the Union, so to speak. Bruce, you're next.
Hello?
Hey, Bruce.
Oh, hi. Hi, this is, yes. My question deals with child custody.
Okay.
First of all, what do you do? I'm kind of losing faith in the lawyer that I'm using now in order to get custody.
Okay.
And I've already gone to court at Dauphin County, and first of all, let me give you the background. Child is 15.
Okay.
Wants to live with father. Lives with the mother. The mother is fighting this to the death.
Mm-hmm.
No matter what, she will not give up. Okay? The child goes to court, loses a day of school, sits in the waiting room for 4 hours in the courthouse in the hallway, and is never called into the courtroom. The judge never meets the daughter, my daughter. Never met the daughter, never spoke to the daughter. Everything revolved in the courtroom around pretty much the mother controlled the meeting. The mother controlled the whole show. The mother did everything she could to bring the child's position as she is rebellious. She is a difficult child.
Right.
That kind of thing. And the judge said, I'm getting the picture. I don't need any more stuff. I get it. I'm seriously very concerned about this child. I mean, she might go down the wrong road, might go into, get into the juvenile problem, and needs psychiatric checking up and all this kind of testing and stuff like that. Okay?
Right.
Meantime, beforehand, a couple months before that, there was a conciliation meeting. The parents were told, me and the mother were told that the child needs counseling. The child is somewhat being rebellious with the mother because the mother won't listen to the daughter. All she wants to do is live with the father and try it out. She's 15 years old.
Right.
She hears all about other kids where their parents say, if you want to live with the other parent, fine, no problem, go. Don't let the door hit you on the way out. Not with this case. Okay? So the mother pretty much and her lawyer controlled, and I was on the defensive the whole time in the courtroom, and the judge said, okay, the child's already gone for counseling. Now, the counselor doesn't even think that there's a problem with the child, that the problem is with the mother and her difficultness.
So your lawyer hasn't really presented that information to the court very well so far, best I can tell.
Exactly. And so now the child's like, Dad, why do I need to go for testing? This is ridiculous. Even the counselor says there's not anything unusual about your child. It's just the mother is being so difficult.
Right.
She's extremely strict and forbearing. She's a control addict, freak, or whatever you want to call it, with her friends, and to the nth degree.
So
obviously,
So Bruce, here's my thoughts. Obviously, there's stuff you'd have to tell me that we wouldn't talk about here on the air that I would want to know if I was going to make a true second opinion for you here. But if in fact the court, your lawyer has the right to call witnesses, and among those witnesses would be the child, and I think a child of that age would be extremely important, and I think most judges would be receptive to talking to a child that age if it's presented to them properly. And what I'm hearing you say is that your lawyer basically didn't say very much, and the other lawyer or the mother pretty much ran the show.
Exactly.
And
Can I get the transcript from that?
Yeah, absolutely. You can buy that from the court reporter.
Okay.
So, Bruce, here's my thought on the matter is, if you're not comfortable with your current lawyer, and I tell clients sometimes when they think I'm a goofball, if you're not comfortable with me, go talk to somebody else to see if you think I'm doing it right or wrong or what they have to say. Sometimes, the client's dead wrong. There's just reasons. Now, I don't know you, right? Okay, and so you could turn out to be the best dad in the world, or you could be the most pain in the butt client in the history of the world. I don't know that. What I do know, though, is that you're obviously not fitting well with the current attorney you have, and the attorney you have may not be very experienced, may not be very good, or for whatever reason just having a bad day, or they're doing very well and you're not understanding their overall strategy. But that's bad on their part, because there are times when my client looks at me and says, why are we doing it this way? And I explain, well, here's our strategy.
Right.
I know you want me to bring up this, and this, but look at this case. This is why we're not going to bring it up. And we're not going to bring up her marijuana use, because then she's going to bring up your cocaine use from 1982. And so sometimes we reach strategic decisions, but the client needs to understand why we're doing what we're doing. And so that's where I would fault other lawyers quite frequently, is they don't spend enough time explaining to clients why we're doing what we're doing.
Well, can an appeal be made of a court's decision?
An appeal can certainly be made within 30 days, okay? However, if the judge has punted it to a counselor, what we would do is jump through that hoop and then get some more hearing time and then appeal that decision if we were still unhappy. So I would need to know exactly what the order is. So I would encourage you to get in contact with somebody like me off the air if you want, and we'll take a look at it and tell you what we think you should do next and whether you should stick with your current lawyer or not. Contrary to popular belief, I'm not in the business of trying to poach other people's clients. Lawyers don't want to steal each other's clients if we can avoid it. So if I think they're doing a good job, I usually just tell you, write your letters if they're doing a good job, just relax. If I don't think they're doing a good job, on the other hand, I'm not going to, even if I like the guy or I know the guy, I'm not going to stick up for him if he's not sticking up for you.
Okay. So, and actually, you can put yourself a plug in for this. What does a initial consultation usually involve?
If we just had a brief telephone conversation like this right now, I wouldn't charge you anything for it on an initial consultation. But if you wanted to come in and have me look everything over and spend an hour talking to you, you'd be looking to spend a couple $100.
Okay. That's to get an idea. And last but not least,
yes.
I know this sounds bizarre, but think about this. My daughter, age 15 and a half, okay? Obviously, she comes with me many weekends and for a period of time in the summer, okay?
Right.
Now this is, I went to the department, police department. I asked that hypothetical question. I said, you're the cops. Let's say somebody calls you and says, I want my child back, and my child says, no, she's not going. Okay. So my child is staying. So
right.
The child stays with me. Does mother have the right to enter? No, not to your house. You've been divorced. Okay, fine. Will the cops intervene and forcibly take the child out to the mother?
They potentially can, and here's what you got to be very careful of. You're not privileged to break a court order, okay? And you're not privileged to help a 15-year-old not follow their custody order either. And so, unfortunately, it puts you in the very awkward position of having to take your daughter and say, as much as I love you, I'm going to ruin all chances of me getting primary custody by disobeying this court order. So you're going to have to go to mom's house for the moment while I continue to litigate this.
So in other words, it would mess things up greatly?
It could mess things up very greatly because judges will say to you, she's 15. If you're a competent parent and this child really loves and respects you, they're going to do what you tell them to do. And if that includes going back to mom's house because I ordered it, then so be it. All right, Bruce, I got to let you go because I got to go to break here.
Thank you very much.
All right. 540-0580. Kay and Jerry, hold on. Hey! Yes, I cannot drive 55, but the speed limit's 65, so it's okay. I think I've said that one once before. Whew. I'm going to be in trial this week, Cumberland County Trial Week, Monday morning. I've got a case up at 9:30 in the morning, which really means in court time. They say be there at 9:30. I'll bet we'll be picking a jury at 11 a.m., and we won't be doing openings until lunchtime if everything goes right. And if everything goes wrong, somehow it'll be Tuesday before anything gets going because the world of the court, the world of the law moves on a very different clock than the rest of the world. So when I tell you something will be done quickly, I probably mean weeks or months. And when I say it won't take that long, that means a year. And when I say this case is going to take forever, I mean we'll both be dead before it's over. So just keep that in the back of your head when we're talking because you have to translate legal time into real time. 540-0580. If you want to stop by and see the trial, it's open to the public. It's a good case. It's an enjoyable one for me. I'm planning on hammering them, so why not? So I'll put some Twitter feeds up so you guys know where to go, and maybe we'll get Shane to fire some information out as we go. Maybe we can do a play-by-play Twitter from the back of the courtroom. We'll see. Oh, they'll probably try to stop me. They let it go on in the Vion trial, so whereas down there in Lancaster, they seem to get really nervous about that stuff. Heaven forbid the public know what's going on in the courthouse. Jerry, you're on WHP 580.
Hi, Carl.
Hey, what's going on?
Great show as usual.
Thank you.
And you're the great man to deliver it. My son, go figure, he's in his early 20s, got a speeding ticket in a local borough or township, doing 42 and a 25.
Okay.
Now he's all hepped up to go fight this because he didn't believe he was guilty of going that fast because there was a car in front of him and a car behind him. But it was a speed trap, and they used a machine called an NRAD.
Yeah.
And he did some research on that and said a lot of states don't rely on them because they're not completely accurate. So he's going to do some research on it and think about this. But I told him from my experience, which is eons ago, you probably either have to pay the ticket up front or you're delinquent on payment of the ticket. Then you get subpoenaed to see a district justice, and if you lose, you'll have to pay court costs and fine, double the fine or whatever it comes up to, surmounts to. But I also told him that sometimes you can have all the best evidence in the world, and it's you, the judge, and probably the officer there, and you might present a really good case for yourself, but they might just say this is a pain in the ass, and it's taking up my precious time.
And so, there's so many different ways that those can play out. Let me explain to you what I tell people. Now, first of all, the good news is he's going to have to pay up front to get the hearing, but they won't charge him anything additional if he loses. He basically will be paid in full if he loses on a traffic ticket like that. They won't assign any additional cost.
On a ticket like that, I guess, what would its label on that ticket?
It should have a total on it. If it doesn't have a total, then they only take $50, and if they only take $50, then he will end up owing more, whether he pleads guilty or is found guilty, but it's going to be the same.
Uh-huh.
That said, let me tell you what we would usually do in a case like his. If I was hired, first thing I would do is explain to him that the world is filled with injustices, and this may be one of them. But some injustices are greater than others, and some require more investment of your time. And so what we would do is go to the hearing and try to work out a non-point offense plea, non-moving violation, keep it off his driver's record, and keep it from affecting his insurance rates. Because bottom line, that's what you want.
Yeah, so you can actually try and negotiate. Obviously, an attorney such as yourself would need to be there to deliberate that, but you can actually do that and then keep points off of his license.
Correct.
Okay, yeah, that is the ultimate goal.
And so we do that. Now, here's my. I always tell people you catch more flies with honey, right?
Uh-huh.
So you go in with the honey, but if that doesn't work, then you try the vinegar. And the vinegar is, okay, let's have a hearing. You want to have a hearing? I know all about. I'll get my book out, and we'll talk about the NRAD, and we'll talk about the reliability of the system, and we'll talk about whether or not the things were properly spaced. We'll talk about whether the beam was broke by any of the additional cars in the surrounding area that might have made it look faster.
Okay.
Blah, 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 blah. And we'll go through, and did you make sure you referenced all the Pennsylvania bulletins? Let's see. So it's a big technical fight, and some judges, you're right, just kind of go, I don't care. Other judges will say, and my favorite is, I have a few judges, I'm not going to tell you who they are, but when you sit down in the courtroom, obviously you haven't worked it out, and you get ready to do a hearing, the judge will say, well, before we have a hearing, Mr. Rominger, what's the bottom line here? Well, Judge, I asked the officer for a deal, and he said no. Officer, is that true? Yeah, it's true. I'm not working out a deal here. Well, what's the bottom line? Is this a points issue? What's his driver's record look like? Oh, come on, officer. Can't we just work? When the judge says, let's work it out, obviously things usually move.
Okay. For something like that, what would your fee entail?
We're looking at around $400, give or take.
Okay. And if I were to call you on the QT and I gave you the township that it was in, would you know if it would be a favorable judge?
Yeah, I could absolutely. Just shoot me an email and I'll tell you. But the short answer is in the average week, if we have 10 speeding tickets amongst the office, I would tell you only one person gets points.
Okay, that was my last question. I was going to ask you what the prognosis for success might be.
It usually can be resolved. But listen. The other thing you got to remember is troopers, unless your son did the "you should be out busting crack dealers" routine on the police officer, which is always a great one. I always ask the client, "Now, were you courteous?"
Oh, that isn't offensive to the judge to say something like that?
Yeah. Right. And so as long as he didn't do that, then usually most officers don't want to jam people up. And the fact that they've had to hire a lawyer satisfies them that they've already paid a hefty fine.
Right. And there's a principle involved that they'd like not to have to relinquish in vain.
Yes.
Okay.
All right, my friend.
I appreciate it, pal. Thank you very much again.
Thank you.
Be good. Bye-bye.
540-0580. Carl Rominger answering your legal questions as frankly as I can. Kay, you're on the air. Kay.
Oh, hi.
Thank you for waiting.
Dr. Carl. There's a question I'd like to know. A power of attorney at a hospital, do you have to renew that each year?
The general rule is a power of attorney does not have to be renewed each year. However, a durable power of attorney or a non-durable power of attorney can include an expiration date in it. And so if it has a built-in expiration date, then it is going to have to be redone frequently as the expiration date requires.
Oh, okay. Then that must have been what happened. They didn't put a date in there, and the people thought the power of attorney was good, and it was no good. So it's always those little things, huh?
Yeah.
And I was wondering if you ever do car insurance claims.
Absolutely.
Accident.
Absolutely. We do a lot of personal injury and accident work.
Okay. And now there is, this is personal. There's one thing I want to ask you, Dr. Carl.
Before you ask it on the air, remember, if it's personal, you might not want to put it out on the air.
No, it's I want to try to make you understand this was the rest of the questions were just sort of things I've heard.
Okay.
Or, people asked me. But my son was ill for 30 years. He was a kidney transplant patient at the Hershey Medical Center. Now, I don't want you to get the wrong idea. I love the Hershey Medical Center. They did well with my son. They did well with me. I mean, the doctors, as far as trying to explain to us what it took them 8 years to learn.
Right.
And but the nursing staff was what I will say extremely, because he died in 2004.
Okay.
In 2004, and I can't get by his death, and which is not unusual.
Right.
But there's one thing that I was even on a committee down there thinking maybe if I can make these people understand, how that.
What are you trying to say here?
Okay. There was 3 times, there was more than that, but there was 3 times that my son had come out of surgery. When he came out of surgery, he went straight to ICU. And
I'm gonna bump you here. You got to get this tightened up a little bit.
Okay. And then when I wanted to stay, the doctors didn't know if he would live through the night, and they would tell me that. They'd say, hey, okay. And I would ask the nurse, may I stay with my son? And, I said, I did a chair, I'll stand by the bed. And they'd say, no, you can't do that. Well, that is not true. You can do that. And it was extremely cruel. And I wondered if there's any action.
I can answer it real quick. The short answer is all that happened more than 7 years ago.
Yeah, my son died in 2004.
Yeah, so you're past at least a 2-year statute of limitations, a 4-year statute of limitations, and probably a 7-year statute of limitations if there were one applicable. But almost every cause for negligence or malpractice or any of those sorts of things, or even intentional or negligent infliction of emotional distress, all end after 2 years. Contract and warranty actions end after 4, generally speaking. So, no, you'd have no legal recourses at all. All right?
Okay. Well, I just wondered because I did think a lot of the hospital, and I have tried through different committees and things to get them.
And that's your only recourse at this point, and I would keep it up, okay?
Okay.
Thanks, Kay.
I thank you.
All right, you take care.
Okay, bye-bye.
Bye-bye. Seems like a nice lady. Sue, you're on WHP 580.
Hi, Carl. I'm in an unfortunate situation where I have to claim bankruptcy.
Okay.
And I have hired an attorney, and I've gotten a letter where they're going to have a judgment served against me from a company. I took this to the attorney, and he said, "Oh, no problem, I'll take care of it. It's, a phone call, you're going to file bankruptcy. It really is not a big deal."
Right.
I got a second letter from the same company, took that to the attorney, and he says, "Well, I did send an answer in, no big deal. I now have a judgment against me." And they're saying nobody had replied to them.
Right.
So now I'm wondering, do I want to get a different attorney? And if I do, what can I do about this judgment? Or in the long run, is it not going to matter anyway?
Well, are you filing a 7 or a 13?
7.
If you're filing Chapter 7, then it's not going to matter because the additional costs of the judgment are not going to end up having to be paid back. So the other side really didn't get any benefit from going forward, so to speak. So my thumbnail sketch, based on what I know, is it doesn't really make a difference in the long run.
Okay.
If you were doing a 13, then sometimes we worry about that because increasing the amount of unsecured or secured debt that you have to write off can change the parameters of what the court can and can't do in terms of working out a 13 schedule.
Right.
So that's the short answer. It probably doesn't matter. Now, whether or not the lawyer actually got back to him or not, what I would like to see is the correspondence. Generally speaking, in my office, if we send something out, we send it to you. If we get something in, we send it to you.
Right. I'm going to follow up with that on Monday.
So you see a paper trail of what's going on, which makes it really hard for me to say, yeah, I did it when I didn't, because I just won't have any timely paperwork. And these days, instead of mailing, we try to get people's email addresses. So when I send out a letter, you get it as a PDF in your email box the same day.
Correct. Okay. Yeah, I'm going to follow through with that. And, obviously, if he's telling me a story, then we have a different problem altogether.
I got to go to break. Shane's actually got the break sign up.
All right. Thank you.
All right. Bye.
Bye.
540-0580. See you after the break. Hey, welcome back. Carl Rominger here, answering your legal questions, 540-0580. And I'm going to be in court this Monday in Cumberland County, so check out the Twitter feed to see what's going on. Mark, how you been?
How you doing, Carl?
Hey, this is our financial guru, Mark. You can find him on weekendappointment.com. But, Mark, you got something else you wanted to chime in about today.
Yeah, a bunch of us were getting together, and there were some politicos there, and we were talking about some court cases going on in Lancaster, and it was rumored, and I want to stress it was rumored, that during a criminal trial, a woman who was testifying against the defendants, one of the key witnesses, was videotaped by somebody in the gallery and then put on YouTube. And I wanted to know if cell phones or any kind of devices like that during a criminal trial, are those allowed to be used?
The short answer is cameras are not allowed to be used, and you can't record in a courtroom in Pennsylvania. Only the Superior Court has some special rules that allow a PCN to do it. And so technically, and this is where courts are struggling, because now that every cell phone is also a high-definition video camera with a decent sound system built in, not only can you get Saddam being hung, you can get witnesses testifying, et cetera, and judges. And courts are very camera shy in Pennsylvania. So I suspect this is going to lead to a bigger crackdown. York County, for instance, doesn't allow anybody but the lawyers to bring cell phones in and employees. So if a video showed up, that would narrow the pool of who it could have been. My experience, I think, in Lancaster is anybody can bring it in, but it's supposed to be turned off in the courtroom.
Okay. Well, thanks for your time, and I'll talk to you later this week.
Hey, why don't we get you back on here in a week or two to answer some financial questions for us, too?
That'd be great, especially with everything going on in the world right now with Libya, Egypt, and, of course, the sadness over in Japan. That would be very opportunistic.
All right, we'll have you on next week or the week after. All right, buddy.
Take it easy.
All right, bye. Hank, I only got a minute, so go fast. Hank.
Hey, Carl, can you tell me what the rules are on eviction from a rental garage? I have a tenant that has been inconsistent paying, and I'm looking to get him out of there, so I want to make sure I'm doing everything the right way.
A rental garage?
All right.
Yeah, you have to give him a notice to quit. And if you don't have a lease, the notice to quit has to give them 30 days to get out, and then you go to the district justice and file an eviction for a judgment of possession. If it's a residential rental, then it's easier for them to appeal it. If it's a commercial rental, like the person's using it for commercial purposes or a business purpose, then it's a little easier to force them out faster. But either way, you still have to do the notice to quit and the DJ filing.
Month to month?
Month to month, on a month to month, you got to do the notice to quit. So I just give them 30 days to get out, post it right on the front door, and or hand it to them in person. It's best to have a third party hand it to them or post it so that you have somebody besides you that can say what date and time it was posted.
Okay, thank you very much.
All right, Hank.
Bye.
Or, of course, you can always come see me, and we'll take care of all of it for you, too. Ken, what's going on? Ken.
Yes.
Shoot fast.
I run a small business, and I was incorporated through a group of attorneys.
Uh-huh.
And I just recently got a letter saying they want me to keep me on their list of possible people to help out. They want me to. I'm thinking it was $125.
Hold on, Ken. Hold on. I'll talk to you off the air here.
All right.
All right, guys. Weekend appointments up for the week. We'll be back next Saturday. In the meantime, you can catch me in trial. Make sure you go to weekendappointment.com, get your free will, or drop off your legal questions there. And as always, get hold of my office. We've got 5 attorneys and offices in Carlisle, Lancaster, and Chambersburg to serve you. See you next week.